right. So this question is from May June 2019, Tort Law Paper 2, Set 2. Okay. So I've given you all some time to actually look at the question and also to try to uh, try to figure out how to answer it already. Okay. So now let us try to answer it together before we look at the marking scheme. Okay. Right, so firstly, let's read the question, yeah? So the question reads, explain and evaluate the factors which must be considered when deciding whether a claimant has consented the risk of harm in tort. Okay, right. So which which chapter do you think this question covers?
Defenses.
Okay, defenses under general negligence, yeah? Okay, and more specifically, what is the question asking you to do?
It's asking about the factors
Fact,
uh,
factors for
for to decide whether the claimant has consent to the risk of harm.
okay, and so consent is basically what part of defenses, what kind of defenses is it asking you to discuss about?
Volunteer non-fit injury.
All right, okay, thank you very much. Okay, so chapter covered is firstly defenses under general negligence. Okay, and then okay, focus. Okay, topic of focus is volunteer non-fit injury. Okay, good. All right. Okay. All right. Now that we have get our bearings ready, okay, on what chapter is covered and what this question asking us to focus on, okay, right? Um, Now we should actually attempt to answer it. Okay. So firstly, introduction. All right. So introduction. What should we start off with?
Define the defense of consent.
All right. So we start off by defining defense. Okay, under defenses under general negligence. Okay, in fact I would say, okay, to actually mention about tort first lah, and then okay go on to define defenses under general negligence. Okay, so how would you just a brief, okay, definition of defenses? Okay, how would you briefly define defenses? Anybody?
A means available to the defendant to protect their rights.
Okay, right. So something about the defendants, okay, trying to protect themselves, not really their rights, okay, but more or less themselves, okay. And of course, after okay, trying to protect themselves after the court has proven that he may be sorry that proven that okay that all the requirements under general negligence has been established, right? So that's why it's important, right, okay, to actually talk about tort and also general negligence first, because the requirements under general negligence comes first, okay, right? You need to go through all that first, then only talk about defenses, right? But like I say here, okay, right, that even though right here our emphasis is actually on defense, okay, right, but we should also highlight the fact that defenses, the topic of defense, okay, or even the talk of defense, it actually comes after we establish, general negligence, okay, or at least the main requirements of general negligence, which is the duty of care, breach of duty of care, damage, causation, remoteness, all those things, then only we get into the defense. Okay, right? So I hope you understand, right? Right. So after that, I think should be the okay. After that, of course, right, we should emphasize a little bit more. Okay, voluntary non-fit injury. And here, just a basic definition or brief definition should be enough already. And how would you define voluntary non-fit injuria?
If claimant has some way consented to what was done by the defendant and was voluntarily taking the risk, this defense will apply.
Okay, all right, you're giving me the textbook answer, but never mind, it's fine. Okay, whereby the claimant has consented to the risk of injury, and so there is usually a complete defense, okay, for the defendant. Okay, something like that, right? Okay, good. Now we get into the thesis statement. Okay, so what do you think the thesis statement should be? What should we actually be talking about for the entire essay? Very simple only, like I say, like, it's mostly rehashing of the question itself. But of course, okay, you not just rehashing it, but also you need to be addressing the question, right? And if you remember, the question asks us to address what? This thing here, yeah.
The factors.
The factors, yeah. Explain and evaluate the factors. Okay. Yes. Okay. So that's about it. So here, okay, I would say it's a very straightforward general question for the defenses. Okay. Of course, more specifically, voluntary non-fit injuria. Okay. So here, right, you probably say something like the thesis statement should be something like, okay, we will, okay, go through the principles of warranty and will explain and evaluate the factors, okay, which will make or which will cause okay, which will cause consent to negate the negate the entire harm done by the defendant, something like that. Okay, right? I mean, you can write any other way, okay, but as long as it sounds more or less like this, I think it should be fine already. Okay, right. Okay, so next one is your point one, and as I say, point one usually is your the bridging, okay, point, okay, right, development point. Okay, so what should we be talking about here first? Anyone?
Discuss the defense.
Okay, discuss the defense in more detail. Okay, and here, okay, I would say, okay, to and here it would be good to emphasize more on the issue regarding uh, complete defense, okay, and maybe make some comparison with some other defenses that doesn't give complete defense, which is known as what? Contributory negligence, right? So just a quick one, okay, right? Because also the question is not asking us to talk about contributory negligence, okay, but here is just one thing to emphasize on the complete defense thing, okay. So that is why, okay, we good to just mention a little bit, okay, all right, okay. Then the next one, okay, will be on okay. What's the next thing that we should be talking about? Still under this paragraph or this point here,
Maybe illegality, like
illegality.
this, yeah, like discuss and compare.
Discuss and compare to illegality. Why? Why would you want to talk about illegality?
Because it's under defense.
Okay. But then this one is a complete different defense already, right? Okay, because now we're actually only talking about the warranty. So how is illegality and warranty connected? This one is usually only connected when we talk about the special cases lah, okay, on passengers in road accidents. So we're not really there yet. Okay, so anything else other than this? Okay,
Cases.
cases, yes, definitely. Okay, it'd be good to talk a bit of cases. Okay, regarding volunteer. Okay, so what case would you highlight here? Okay, I would say that the case that you can highlight will be,
The
yep.
constable.
Sorry, what is it?
The Kirkham and Chief Constable of Greater Manchester.
Kirkham was the Chief Constable of Greater Manchester. Okay, what is that case about? This one, I think this is about the suicide situation, right? Okay, where it says that the defense, okay, I mean the defendant tried to raise the defense of volunteer, but the court said that they couldn't because the claimant is not of sound mind. Okay, okay, fine. Okay, we can just put that a little bit there. Okay, right, right. By saying that, okay, however, okay, there are certain requirements, okay, that must be considered before we can allow the defense of volunteer. And so not in every situation, not in every situation, volunteer will be allowed as a defense, okay, such as a situation regarding the state of mind of the claimant, as seen in cases such as Kirkham, versus Chief Constable of Greater Manchester. Okay, Manchester, 1990. Okay, something like that, right? And so right now, okay, of course, the next thing that we should be going through is next thing that we should really be going through is the factors and actual requirements of volunteer. Okay, right? So basically this point one is just to emphasize lah, okay, emphasize the fact, okay, that it is a complete defense, okay, and so therefore not in every situation they will allow it. And then, okay, we only say after that we will be talking about the actual requirements. Okay, right? So okay, point two already. Okay, so usually, okay, right, because the question the issue with volunteer, okay, usually concerns consent, right? Okay, the issue with volunteer, okay, usually concerns, okay, the concept of consent, or okay, more appropriately, what it means or amounts to consent. Okay. Okay. So, what do you think consent is? Anybody?
Has the claimant
Permission.
Sorry.
Permission.
Permission. Okay. Fine. Okay. Consent could mean giving permission. Okay, what about the other girl? The other girl also say something just now. What is it just now?
It's like has the claimant like accept those risks through his conduct?
Claimant accepted the risk through his own conduct, especially, right? Okay, and conduct could mean, okay, something which is done verbally or by action. You mean to say, okay, that you say lah something like, okay, that, hey, I've already agreed to this risk, or action is like, by going through with it lah, something like that. Okay, right. Now can we like go through like some cases already where where people actually give actual consent or didn't give actual consent? Just give me the first case first regarding giving of consent.
Smith and Baker.
All right, good. Case of Smith versus Baker, 1891. That is an example to show you that the claimant has given or not given consent.
No.
Not given consent, has not given consent. Okay, can you just very quickly just summarize the case for me? What happened there? Right, this might be a review for you, a quick revision for you.
Because he is taking a
Because he is taking, oh, you cannot really hear you, taking a risk, okay, that he did not consent to lah, okay, as he was forced, right, to work in that dangerous condition. Right, this one is about the quarry situation, I think, if not mistaken. Yeah, the quarry situation where there is something over on top of them, okay, right? Then the employee did complain to the boss already, saying that very dangerous. The thing that's like hanging on top of them, okay, can actually fall anytime, and apparently it did, okay. So in that situation, okay, they are actually forced to work in that dangerous condition, so therefore no consent given. Okay, now the other case where there is consent given.
Imperial Chemical Industry and Shadwell.
Okay, Imperial Chemical Industries versus Shadwell, 1965. Okay, shows that consent is actually given, right? Why? Come very quickly, tell me.
The defendants decided to do the test of detonators without taking precautions, and
Mm-hmm.
as a result, there was an explosion.
But the defendant decided, okay, to carry on with the detonation, okay, without safety or something like that, right? Okay, safety precautions, and as a result, an explosion happened, okay, which they were actually warned about before. Okay, all right, so something like that lah. Okay, right. So to summarize this whole thing, okay, so these two cases, these two contrasting cases, okay, regarding consent, especially, okay, is actually with regards to whether or not, okay, the claimant actually knows the risk. Okay, so to summarize, okay, summarize this discussion on consent, okay, by saying that knowledge, okay, understanding, okay, knowledge and understanding of the risk, okay, of the risk taken is of, okay, importance, okay, when we want to establish volunteer. Okay, because okay, consent must be informed as well as freely given. Okay, so here we can relate a little bit back to Smith's case to say that consent was definitely not freely given. Okay, but of course, the case of Smith versus Baker, right? Okay, you must actually illustrate in detail first, lah. Okay, in order for you to actually relate this thing to it again. Okay, right? Okay, so I think that's about it for this. Okay, let me see if there's anything else. Oh yeah, okay. Then one more thing that you did mention just now, right? Kirkham's case, right? Kirkham. Right, this one I just put it here for you, since you all just already mentioned it already. This one is regarding the state of mind. Okay. However, okay, right, as mentioned above, mentioned earlier, okay, in Kirkham's case, right? If the claimant is not of sound mind, okay, he also cannot possibly give consent, okay, to the risk. Okay, so something like that. Right, so this is just something extra lah. Okay, so it's like an evaluative thing already, I would say. Okay, so I think we are more or less done with point 2. Okay, where we're actually talking about what it actually means by consent. Okay, and also whether or not there's actual understanding of the risk and all that or not. Okay, and also whether or not they've actually taken the risk, that kind of situation. Okay, right. Other than that, now the next thing that we can actually be talking about is a situation, okay, special cases situation, I would say. Okay, because this one, I mean, if you talk about um volunteer, right? Okay, consent is basically the bulk of it already. So you go through like these few cases, these few main cases, I would say, it's actually more than enough already. Okay, but then now here, right, because the question is more specific to volunteer only, okay, right, so we can actually talk about the special cases, like just now somebody actually said, okay, how it relates to illegality. This one is with regards to the passengers in a road accident situation. Okay, then other than that, you also got the sports situation and also the rescuer situation. Okay, so the next one is of course, okay, point 2, so point 3. Okay, so discuss about the other special situations, okay, where the issue with consent, okay, is not easily applicable. Okay, all right. Okay, because of the circumstances of those cases. Okay, right. So of course the first one is the passengers, okay, in road accident situation. Okay, okay, can you tell me what is this all about? Passengers, oh sorry. Okay, can somebody tell me what is this all about and how is it that consent may or may not work for this kind of situation?
Drivers and motorists cannot attempt to avoid their liability under volunteer.
When they have a passenger, right, okay, with them, all right, okay, so
Yeah.
right, so this is a situation whereby, okay, drivers cannot use what call it, the volunteer to say that passengers have taken the risk, okay, when they sit in the car with them, okay, because in this kind of situation, okay, there is, okay, policy against it, okay, because otherwise, okay, people wouldn't actually, if you don't have this kind of policy, right, okay, then nobody would actually want to be passengers already, okay, right, okay. Now give me one case example for this. There's actually only one case just give me one case example. What's the name of the case? Okay,
Pitts and Hunt.
yeah, Pitts and Hunt. Pitts and Hunt, 1991. Okay, however, this actually also relates a little bit to illegality. Whether or not you actually want to talk about illegality or not doesn't matter, because this, we are just talking about this only. Okay, we're talking about how in this kind of situation, okay, right, consent doesn't actually work, okay, right, that's all. Okay, so whether you want to talk about illegality or not is completely up to you lah, I would say. Okay, the next one is with regards to sports, okay, which is of course a bit more here. Sports, okay, sports generally. Okay, so in sports situation, okay, can the other girl tell me, okay, right, in sports situation, is there consent or no consent?
Depends on whether they follow the rules or not.
Okay, good, all right. Right, whether there is consent or not would depend on whether the people playing the game actually follow the rules or not. Now, there are of course some contrasting cases. Can you just give me a case example where they actually follow the rules first?
Sims and Lay Rugby Football Club.
Okay, seems a rugby football club, 1969. Okay, just very quickly, what happened here?
The claimant broke his leg when he was tackled and thrown against a wall. The court held that because the injury occurred during the course of the tackle was within the rules of the game, the defense on volunteer applied.
Okay, good. Okay, because the tackle happened within the game and also within the rules of the game, okay, warranty applies. Okay, now can you give me a contrasting case? All right, never mind, this one I give you lah. This one easier, I give you. Okay, so the case of Smolden versus Whitworth, 1996. Okay, whereby here what happened was that the the okay, situation involves some children, okay, who are underaged, okay, sorry, playing rugby as well, say rugby, okay, but okay, because of their age, okay, there are certain rules against playing a certain way, okay, and yet the referee, the coach or someone, okay, right, someone, okay, and yet they played against those rules, so consent is not given, right? Okay, so just some quick contrasting case there should be enough already. Okay, I think that should be enough, although there's actually a few other cases, but again, right, okay, all these cases, right, should actually be given in more detail, okay, right? And then the last one, other than sports, okay, although we're still talking about, I mean, still about play, okay, but not necessarily sports, okay, is about what? Horseplay. Okay, can the other girl tell me what horseplay is all about?
No idea.
Huh, no idea. What about the other girl? No, no.
Under rescuer, is it?
No, it's not under rescue. It's actually still under sports situation. Right, never mind. Okay, I hope you can see in your textbook there. Yeah, okay. Blake versus Galloway. Okay, under the case of Blake versus Galloway. Okay, right. So this is like revision for you already. Of course, I remember that I've gone through this with you all before. Okay, Blake versus Galloway, 2004. Okay, where it concerns children just playing around. Okay, right. And while playing around, okay, there are tacit or implied rules, okay, against playing in a certain way. Okay, because usually it means playing in a very rough way is not consented. Okay, so like in this situation, right? Okay, as long as they played it correctly, okay, like in this case they were throwing stuff at each other, okay, right? So if they are like throwing the usual stuff, so it's fine. But if they start throwing stones at each other, okay, then definitely, okay, the other person didn't actually consent to it already. Okay, so I hope you all can find this case. Yeah, can find this case or not? Blake versus Galloway in your textbook there.
Can.
Good. Right. So that's another thing. Okay. Special case. There's actually another one regarding rescuers, but that will depend on whether or not there's actually enough time for you to write the essay, like, because it seems that there's quite a lot of things already, okay, that we've actually talked about. Okay. So whether or not you want to talk about rescuers is completely up to you, lah. Okay. Because rescuers also there's the issue with the consent as well. All right, so with that, okay, I would say, okay, should be more than enough already, okay, for an essay. So therefore, okay, we good to actually go straight into conclusion, okay. Then now, okay, we will look. I'll let you look at the marking scheme. Hold on, yeah, marking scheme. Let me bring it up. Okay, so marking scheme, okay, nothing much because like I say, right, this question is pretty much straightforward. Okay, so immediately, okay, nothing much to talk about. Okay, just need to elaborate on all these other things. Okay, then it should be fine already. Okay. Right, marking scheme. This question concerns the defense of consent, okay, voluntary non-fee injuria, no problem there, which is a general defense in tort. If pleaded successfully, it provides a complete defense for the defendant. But then, like I say, right, you can actually make some comparison with the with the contributory negligence, okay, right, to just get some perspective about what it means by complete defense or for the defendant, okay, right. Then, okay, some of the things that I can go through, okay, candidates should explain the elements required to establish the defense, including knowledge of the risk, understanding of the nature of the risk, consent which is freely given, use of the defense in negligence, use of the defense in trespass to person. Okay, so we've actually more or less covered all these things. Okay, when we go and discuss about consent, what it means by consent, and also go through some of the cases, okay, with regards to consent. Okay, but I think the only thing that we didn't go through is this one, or did we actually? We did, yeah, yeah, we did, with regards to especially this one here regarding the rugby situation. Okay, right, whereby tackle. Okay, so this tackling part is actually the trespass already lah. Okay, so it'll be good they mention, okay, trespass here. Okay, right. Then the other one, okay, next one here, candidates should then address the critical analysis element of the question. Okay, potential points for discussion are knowledge versus understanding of risk. This one is basically this part here where we talk about Smith and Baker and also Imperial Industries case, right? Whereby you talk about they know that it's dangerous, but they did consent to it, okay, right? Like Smith and Baker especially know that it's dangerous, definitely, okay, but did the worker consent to it? Definitely not, okay. So this is the part, okay, that you need to actually be elaborating on, okay, with regards to the critical analysis part, okay. Lack of choice, also same thing here, employment situation. Okay, lack of choice, duty to act. This one is with regards to the rescuer situation, okay, which we did not have enough time to talk about, okay, but if you have enough time, you can actually put that in as well. Consent to sport, especially, okay, consent to sport, okay, so we did actually talk about sport, and then we did also have a contrasting case, right? So same thing, you can use these two cases to actually talk about it. So actually, right, okay, I would say that either the evaluation or the critical component part, okay, is within all this discussion itself, or you can separate it into point four. Doesn't really matter. That's why, like I say, there's a lot to talk about, okay, to the extent where maybe, okay, there's not enough even time for you to actually talk about the rescuer situation, because that is another bulky discussion going on there. But if you feel that you can write fast enough, then it's okay for you to actually talk about the rescuer situation, because you can see here, even in the marking scheme here, there's actually mention about it, okay. So it should be something that you should be discussing now. But again, if you have not enough time, okay, right, you can actually compensate for the more detailed discussion of the other stuff, okay. Okay, then medical treatment. This is actually also something which concerns with the rescuer, although not necessarily rescuer, so it can be something by itself lah. But this one actually, okay, this one you need to actually uh, overlap this. Sorry, this one you must actually relate to another thing already, another chapter already, with regards to the if you remember, okay, bolon bolito, professional skills and all that, okay, right, medical treatment, okay, the thing regarding duty to explain. So this one actually does overlap with the other chapter already lah, okay. But again, right, okay, it depends on your timing and all that, okay. But you can also just put it as a small little thing lah, okay, right. Okay, then critical analysis is required to achieve a higher benchmark, so nothing much there, okay. Right. Any problem before we wrap it up? All right. So if there's no problem, okay, I would say that we are more or less done with this question already. Okay, and this question is quite straightforward. Okay, not much of an issue. That's why you can look at the marking scheme also. It's quite straightforward lah. Okay, the only thing that you need to really address is this critical thing only lah. So as long as you understand, okay, for example, how these two cases work, Smith and Baker and Imperial Chemical case, right? Then try to like evaluate it like, okay, the differences can relate back to the issue of consent and volunteer and all that, okay. I think it should be fine already lah. But this is only just one of it. Other things that I can talk about is also things like the sports thing, okay, right, the thing regarding the sports, okay. So that's about it lah, I guess, okay. Yeah, and this one, especially this one here, okay, because just now when I was going through with you all the time, okay, you all like not too sure what's going on, okay. So just like lah, okay, that this Blake versus Galloway thing can also something that can be critically evaluated on, okay, especially this one here, I would say, understanding the nature of the risk, okay, what you actually consent to, okay, to play normally or to play something else altogether, okay. Right, if there is nothing, then I guess y'all can leave already lah. Thank you very much. I'll see you all next week.
Thank you.
Thank you, sir.